Hello, everyone, and welcome to Uncivil Law. For today's case, we have the state of California trying to prevent the movie site IMDB from providing information as to how old actors and actresses are. They wanted to prevent IMDB from publishing age information. And IMDB said, no, you can't do that. That's a First Amendment violation. And we have a decision from the Court of Appeals for the Ninth Circuit. This is the case of IMDB versus the Screen Actors Guild. In this case, California wrote a law pretty much specifically targeted at IMDb to prevent them from providing this information because they didn't want people to unlawfully discriminate on the basis of age. So we're going to read this case and see where the First Amendment interests come out. Let's get started with this. In 2016, the state of California, at the behest of the Screen Actors Guild, enacted Assembly Bill 1687, which prohibits a specific category of websites from publishing the ages and dates of birth of entertainment industry professionals. The statute appears to target a specific entity, IMDb. Yet by its literal terms, it didn't specifically target IMDb, but it was written in such a way that IMDb was the only organization to which it applied. That's what they're talking about. IMDb sued the state to prevent enforcement of the statute, arguing it was a First Amendment violation, along with other constitutional guarantees. So we want to prevent IMDb, and only IMDb, incidentally, because, again, we wrote it specifically to target them. But we want to prevent IMDb from sharing factual information, such as a person's age and date of birth. So that seems constitutionally suspect. We are basing speech on subject matter. That seems like a constitutional no-no. So let's read on and see what happens. True to its long-form name, the Internet Movie Database, or IMDb, operates a free, publicly available website that offers a comprehensive database of information about movies, television shows, and video games. Visitors to IMDb can pursue movie reviews, trivia, plot summaries, and fictional character biographies. The site also contains encyclopedic entries on cast and crew members in the industry. Often, but not always, these biographical details contain the age or date of birth. In total, IMDb contains more than 3 million unique pages for titles and more than 6 million entries for cast and crew. As of January 2017, it ranked as the 54th most visited website in the world. In 2016, citing concerns about age discrimination in the entertainment industry, SAG sponsored legislation that eventually became Assembly Bill 1687. SAG called out IMDb specifically for facilitating discriminatory conduct, citing an unsuccessful lawsuit by aspiring actors against the company. So the claim here is that IMDb is helping to facilitate age-based discrimination, which may be illegal. And I use the word may here with some qualification, because acting itself implies some First Amendment interests that employment law also has to contend with. So normally, if you're discriminating on the basis of sex, for example, you can do that for a bona fide reason. Normally, as an employer, you can't discriminate on the basis of race or basis of age, with or without reason. But when it comes to acting and entertainment in that sense, it gets tricky, because now there's a First Amendment interest that has to be done. If you want to portray a certain kind of character, you may have to have someone embody that character. So you may want to have someone specifically young, or specifically old, or specifically of one race or another, or so forth and so on. So by the strict terms of Title VII of the Employment Law or Civil Rights Act, you can't discriminate. But there is a First Amendment interest here that has to be balanced in. But here, it's like they're saying you can't even share the information because of what may or may not be unlawful discrimination when we get into the specifics. So that seems a little constitutionally suspect on its own. The California legislature passed the measure, the governor signed it into law, and the statute took effect on January 1st, 2017. The statute contains a controversial provision. If a subscriber asks a provider to remove his or her age or date of birth from a paid-for profile, the provider must also remove from public view in an online profile of a subscriber the subscriber's date of birth and age information on any companion site under its control. So IMDb has effectively two websites. They have one for industry professionals, and they have one for the general public. And you can pay for a profile on the paid portion of it, which might help provide information to potential agents and things like that. So you might want to include some information that would be available to them. But the rule said that if you asked for your age to be excluded from the paid version, then you also had to force the company to remove it from the unpaid version, so that you could remove it from the paid version and force them to remove it from the unpaid version. So that was the controversial aspect. The district court later granted IMDB's motion for summary judgment on the First Amendment facial challenge to Assembly Bill 1687. First, the district court rejected the state's and SAG's attempt to deflect any level of scrutiny under the First Amendment. Thus, the court concluded that Assembly Bill 1687 could not properly be considered a regulation of voluntary commercial contracts because it neither regulates any existing agreement between the subscribers and IMDb Pro, nor imposes any after the fact requirement on IMDb not to disclose information provided to subscribers. So one of the things the state said was, "Oh, we're just regulating contracts." It's like, no, you're not. So no, that's not going to fly. The district court further dismissed the contention that statute was either a law of general applicability, a law that regulates commercial speech, or a law that regulates speech that facilitates discrimination. The court therefore proceeds to a strict scrutiny analysis. So yes, there might be some hypothetical First Amendment exceptions that apply, but none that apply to you. You're not regulating commercial speech. You're not regulating the contracts. You're not regulating advertising. You're not relating product marketing. You're not doing any of those things. So yeah, you try to squeeze it under those labels, but those labels actually mean things, and you're none of those things, so you can't do that. We first address a fundamental disagreement between the parties. Which portion of the statute should be the focus of our analysis? The statute imposes two separate but closely related prohibitions. First, it forbids the publication of age information, upon request, of a paid subscriber hosted by the commercial online entertainment employment service provider. Second, the statute prohibits a provider from publishing age information on any public companion website, such as IMDb, without regard to the source of information. So we don't care how you came it, but you can't produce that information. Next, we must determine whether Assembly Bill 1687 implements a content-based restriction on speech subject to the First Amendment scrutiny, or whether it is simply a law of general applicability immune from the strictures of the First Amendment and state and SAG contended. We conclude that's the former. So if it were a general law of neutral applicability, then probably you'd be okay. At best, you might be looking at intermediate scrutiny, but you wouldn't be looking at strict scrutiny. So yeah, if it's a general, this is the classic Lemon versus Kurtzman test, I believe is the name of the case, from the U.S. Supreme Court, but everyone just calls it the Lemon test because that was the guy's name. So yeah, in that case, if it's a general rule of neutral applicability, then we don't apply strict scrutiny. But it's like, no, this isn't a general rule of neutral applicability. This is not general. It's written basically specifically to target you, and so that makes it not general. And yeah, it's not neutral in its application because it's prohibiting what kind of things you can do specifically on the basis of that speech. So that no, that's not going to work. The First Amendment, as incorporated and applied to the states by the 14th Amendment, curtails the state's ability to implement a content-based restriction on speech. A speech restricting statute is content-based if, by its very terms, it singulars out particular content for differential treatment. So, you're kind of there. In contrast, a law of general applicability does not offend the First Amendment simply because its enforcement may have an incidental effect on speech. On its face, Assembly Bill 1687 restricts speech because of content. It prohibits the discrimination of one type of speech, namely date of birth or age information. And perhaps more troubling, it restricts only a single category of speakers. Thus, Assembly Bill 1687 imposes a direct on significant restriction on a category of speech. It does not apply generally. The statute affects IMDb speech in a manner that's far more than incidental, and therefore it must withstand First Amendment scrutiny. In the majority of cases, we apply the most exacting form of review, strict scrutiny, to determine the validity of a content-based restriction on speech. Yeah, so we've discussed this in passing in different levels, like different levels of speech are reviewed on different levels of ground. So commercial speech, especially advertising, for example, intermediate scrutiny, if it's time, place, manner restrictions, so that's subject matter neutral, viewpoint matter neutral, intermediate scrutiny. But here we're talking about content. It's a content-based restriction. So now we're going into strict scrutiny. This is basically the hardest test we have. So you have to show a compelling governmental interest and least restrictive means. Normally pretty much good luck with that. It's pretty hard to meet those thresholds. The courts permit content-based restriction on select categories of speech, which are of such slight social value that any benefit might be derived from them is clearly outweighed by the social interest in the order and morality. The courts similarly afford reduced protection to commercial speech. Nevertheless, state legislatures do not have a freewheeling authority to declare new categories of speech outside the scope of the First Amendment. So yes, if it were true obscenity, then yes, maybe. That maybe you can do that. Or if it were a true commercial regulation, then maybe. but you can't just create new categories out of nowhere. No. First, the content found in the profiles on the IMDb's public website does not meet the standard for commercial speech. Commercial speech does no more than propose a commercial transaction. The facts here do not present a close question. Public profiles on IMDb do not propose a commercial transaction. The content is encyclopedic, not transactional. Because IMDb public profiles do not propose a commercial transaction, we need not reach the factors in Bolger. But even if the question were close, which, it's not, nothing in the record indicates that IMDb profiles either are an advertisement or refer to a particular product. Thus, even assuming IMDb has an interest in profiles, the profiles are not commercial speech. So, yes, as the court is pointing out here, when we're talking about commercial speech, we don't mean all commercial speech. We mean specific kinds of commercial speech, and most notably, advertisements, product descriptions. So, there's an interest in the government in regulating those, in not allowing the things to be false, and maybe requiring certain mandatory disclosures about safety or other issues. So, there's some interest there that are legitimate. But just because it's commercial in nature doesn't make it commercial speech. So here, the speech is not commercial within this meaning because it's not proposing a sale or a product. It's describing a human being. And it's not saying hire this person or here's how to contact that person if you're interested in them working for you. It's just providing straight factual information. There's no commercial component to this for the average normal person. So it's not commercial speech in that meaning. Second, we reject the Screen Actors Guild reliance on Pittsburgh Press to argue a lower level of scrutiny applies because the Assembly Bill regulates activities that facilitates illegal conduct. So whether this is a facilitation. In Pittsburgh Press, the Supreme Court addressed a challenge to a city ordinance that prohibited discrimination on various bases, including sex. To support the prohibition, the ordinance forbade the dissemination of advertisements that indicated any discrimination on the basis of sex. So here, what the regulation in question is it was prohibiting a commercial ad, a classified, that said, we will only hire people of certain races or certain sex. It says, no, you can't make that advertisement. So it's prohibiting the newspaper from running ads that by their terms are discriminating. So that was that case. The court upheld the ordinance as consistent with the First Amendment, noting the newspaper's First Amendment interest was altogether absent when commercial activity itself is illegal. So yes, the question here is very narrow in nature and very constrained in its construction. So we're talking about newspapers, but we're talking about newspapers in a very limited context. We're talking about paid for advertising and classifieds, people who are buying ads to sell something, to buy something, to offer jobs for hire. So here they are offering commercial speech. The speech is by its own nature commercial in nature. Buy this, sell this, work for me, whatever. And so we're prohibiting the newspaper from accepting classifieds that discriminate on the basis of sex because you can't discriminate on the basis of sex. So we're preventing you from advertising about that as well. And they said, well, it's consistent with the First Amendment because you can't discriminate on the basis of sex. So you can't advertise that you want to because you can't advertise things that are false or illegal. You can't advertise something that is not true. So you can regulate the speech because of inherent commercial nature. You can't in fact discriminate on the basis of sex. So you can't say that you will because then you would just be engaging in this commercial speech that is by its own terms prohibited. But that's not the fact pattern here, right? The things that are being provided from these third parties are not comparable to classifieds because they're not offering anything for sale. So the case is distinguishable. The rationale does not apply here because Pittsburgh Press implicates only those instances in which the state restricts speech that itself proposes an illegal transaction. So yes, you can't engage in the illegal transaction and you can't advertise that you want to engage in the illegal transaction. That makes sense. But we find nothing illegal about truthful, fact-based publication of an individual's age and birth date when that information was lawfully obtained. So there's nothing unlawful here because it's not proposing anything. It's just simply saying, here is a fact. So if someone does something illegal with that fact, that might be a problem, but we don't prohibit that kind of speech. You can actually publish manuals that tell people how to make homemade, munitions or something. Now, whether or not they can do it or not is a whole other set of problem, but the speech itself is protected. If we accepted SAG's interpretation of Pittsburgh Press, That would require this court to permit restriction of not only speech that proposes illegal activity, but also facilitates facially inoffensive speech that a third party might use to facilitate its own illegal conduct. So, yes, we would have to ban speech that might be used illegally. And that covers a whole new can of worms. But as the Supreme Court has noted, it would be quite remarkable to hold that speech by a law abiding possessor of information can be suppressed in order to deter conduct by a non abiding third party. To be sure, courts have long recognized the First Amendment and the individual's right to privacy present a compelling concern. So we do have an interest in privacy, but perhaps not this particular aspect. We set a high bar for cordoning off new types of speech for diminished protection. Thus, although the courts have recognized some conflict between the First Amendment and privacy interests, and there are, but as there are many times, there are often conflicts, we lack the pervasive evidence in this case that would permit a conduct based prohibition on age information without subjecting that restriction to strict scrutiny. It's also a little bit hard to believe that age information is in the category that could possibly overcome the First Amendment interest. If we were publishing like their home address, like maybe, but then we get into other issues too. But maybe private. There are certain private details that could be excluded, but age information, no, it's a little bit too broad to fold into whatever category you're trying to create. Because AB 1687 does not regulate commercial speech that is as nature commercial in nature, or any other form of speech entitled to reduced scrutiny, only we apply strict scrutiny to determine validity. Even if a state intends to advance a compelling governmental interest, we will not permit speech restrictive measures when the state may remedy the problem by implementing or enforcing laws that do not infringe on speech. So, yes, if we have other ways of doing this other than infringing on speech, we're definitely going to be doing that, yes. Similarly, a state fails to narrowly tailor a speech restrictive law when it eliminates one form of speech, while at the same time allowing unlimited types of other speech that creates the same problem. Yeah, so it's not narrowly tailored in its nature if you allow some speech of one kind but don't discriminate against the other speech of other kinds, because then it's arbitrary and capricious, and you can't do that. You'd have to treat it all the same, and you're not doing that. That's a problem. On its face, AB 1687 restricts only websites like IMDB, with pretty much just IMDB because of how it was written, but yeah, while leaving unrestricted every other avenue through which age information might be disseminated. So, like, yeah, the whole thing is silly because, like, you can get the information from 1,000 other places. And so you're not treating this on the same terms as you're treating it everywhere else. Unlawful age discrimination has no place in the entertainment industry or any other industry. Okay, I do have to quibble with the court here because what constitutes unlawful age discrimination in the entertainment industry may be different than other industries because the entertainment industry has a unique First Amendment interest. If they're interested in portraying certain characters, they may need to discriminate on the basis of age. So I don't really like this sentence the way it's phrased because one, it's a bit of a truism, and two, it's also misleading because you would actually have to ask First Amendment questions when it comes to an entertainment industry discrimination on the basis of sex, age, race, or anything else, where you wouldn't normally have to ask that question. Unlawful age discrimination has no place in the entertainment industry or any other industry, but not all statutory means of ending such discrimination are constitutional. Here we address content-based restrictions on speech and hold that Assembly Bill 1687 is facially unconstitutional because it does not survive First Amendment scrutiny. We affirm the District Court's grant of summary judgment. So that is the case of IMDB versus Screen Actors Guild from the Court of Appeals for the Ninth Circuit, in which the Ninth Circuit reached the right decision. Amazing. The Ninth Circuit says that yes, freedom of speech is a thing that continues to exist. And you are saying to IMDB they can't provide age-based information, which is subject matter, and that's strict scrutiny. And no, this isn't commercial speech, so you actually have to meet the test and you didn't come anywhere close. So IMDB can continue to provide age-based information to actors and actresses. And that is the end of the coverage of this case.